SJC-13132, Commonwealth v. Aaron Bookman.
Okay. Attorney Tomposki.
Yes, good morning, Chief Justice Budd, members of the court. Michael Tomposki on behalf of Aaron Bookman. I am asking the court to grant Mr. Bookman a new trial because relevant evidence on the issue of motive was excluded by the trial judge.
How was any of this preserved at all?
So I think on the drugs specifically,
How about the knife? Let's start with the knife.
I think on the knives, correct, we're into a substantial likelihood
Okay,
of
and then on
miscarriage of justice
drugs,
damage.
co-defendant's counsel brought a motion and argued the motion to allow the drugs. Your client's lawyer said nothing.
So he said two things. He was asked if he was introducing third-party culprit evidence, and he said, I can't imagine. And then as to the drugs specifically, he said, I think the jury ought to hear it. And so the question, I guess, is how to reconcile those two statements and whether I think the jury ought to hear it in conjunction with the co-defendant's pretty clear objection and argument is enough.
That's the quote, I think the jury ought to hear it, is the sum substance of the argument.
It is.
All right.
Right.
Let me ask you a different question then. You argue in your brief about this Mateo Morales incident, right?
Okay.
That class had been arrested for that. Where's the connection between that murder and this case?
There's no evidence of a clear connection. It wasn't developed. I think
Did it precede this event or did it postdate this event?
the
Morales
homicide
homicide.
postdated the homicide in this case.
It postdated the homicide.
Right.
So if it didn't exist at the time of the murder, how is it relevant for third-party culprit?
So, I mean, the main thing that I'm pressing is the drugs, quite frankly.
Okay, but in your brief, you raised Morales. Are you conceding that not an issue now?
Well, I think if the drugs were permitted.
All right, answer my question.
Okay.
Are you conceding that Morales is not an issue? The Morales murder is not an issue?
I'm not conceding that.
All right, then what's the connection?
Sure. So the connection depends, I think, on.
Don't say drugs in the next thing you're going to say. What's the connection between Morales and this murder?
That the victims knew who it was that fired upon them, and this tends to suggest it was someone other than the defendant.
On a murder that happened after the shooting?
Correct, because they seemed to, yes, because they indicated they knew who was responsible for shooting the victim in this case. They indicated that at the hospital. They then indicated an intent to seek revenge. Then there's evidence in the trial record that Mr. Bookman was, at least for 3 weeks, that's I think what's in the record, was out and not targeted for, at least as far as the record is concerned, for any retaliation. The incident was New Year's Eve, and he went to the police on his own on the 19th of January, so he's out. He's not targeted. There's no evidence that Mr. Acevedo is targeted. They both go about their lives, at least for some time. And so
let me get this right. So because Cass killed someone 2 years after the murder, it shows that Morales was the real shooter?
Well, I think it's not that it shows it. I think we put this all. The question is whether this, coupled with the other evidence that was excluded, suggests is relevant to the issue of motive. I think that's really the question. It's certainly not conclusive.
And we don't get into the realm of speculation on this?
I think if it was all.
And this was never argued at trial, to this theory?
Well, the revenge theory was.
This theory that you're giving me now, that Cass killed someone 2 years later, so it proves that they did a better job investigating it than the police. This wasn't argued at trial.
You mean as in the closing argument, you mean?
No, it wasn't raised in front of the judge for admissibility purposes.
So, not precisely in the way that I've articulated it, perhaps. But I think
that's a stretch. Not at all.
Well, I think what was raised is is that the defense wanted to put on evidence that someone else had a motive to do it, and that perhaps someone else did it. Obviously, that was sort of
And that was tied to this got to be other rival drug dealers around,
right.
not this whole Morales.
Well, I think it may have been sort of column A or column B, and I understand what
Really?
I understand what was raised. I think what was raised generally was the issue that some of this evidence the jury ought to hear, and none of it was heard by the jury. And I think that was wrong. That was an error. And if I can get back to, I think, your initial question on standard of review, which was how to reconcile the defense attorney's two statements that I'm not offering third-party culprit evidence, but the jury ought to hear about the drugs. And I think it may be a question somewhat of semantics, because the doctrine of third-party culprit frequently has a specific meaning, which is essentially asking the judge to relax certain evidentiary rules on hearsay and permit evidence that would normally not be permitted because of its hearsay character into evidence as proof that someone else committed the crime. So I don't think
What's-
Go
oh.
ahead, please.
I was just going to ask, what's the if the jury found out that the people in the car were drug dealers, anyway, what would be the purpose of having the drugs admitted?
You mean because they found out that they
Since
did
they already
have?
knew, right.
So I think there's a difference between historical drug dealing and drug dealing at the moment of the murder. And so what the jury heard was evidence of historical drug dealing in terms of being incarcerated or having a record of it. But the question was, what were they doing that night? And I think that was what the drug evidence was relevant to, what they were doing that night, and whether that, you can think of it either as giving someone else a reason, or at the very least, it was relevant to rebut the Commonwealth's stated motive. And I don't know that that was framed by Mr. Aceveto's attorney before this court in quite that way, but essentially the Commonwealth's, one of their biggest pieces of evidence in this case was the supposed rivalry between the two neighborhoods in New Bedford, and there was a litany of evidence of prior acts of violence and threats and all things like that as evidence that the defendants had a reason to kill the victim in this case. And so what I would suggest is that any evidence that suggested something else was the reason was relevant, whether you call it...
Let me ask you this, because you keep on referring to your touchstone as relevance.
Yes.
And that is not the touchstone for third-party culprit evidence. That's not the standard for third-party culprit evidence. And the problem here is the analytical gap that exists between the evidence you want to put in and what the standard is for third-party culprit evidence. It's relevant, and it has to be of substantial probative value from our case law and Mass Guide to Evidence 1105. And that's not enough. It not only has to be relevant and have substantial probative value, but it can't be remote, it can't be speculative, and that's not enough. You also have to recognize, as the cases law does, that this evidence has an inherent undue prejudice in that it can divert the jury's attention from the issues to collateral issues. So when you keep on referring to your touchstone of relevance, it's going to require a lot more for this unpreserved error in a circumstance where the proponent of the evidence is required to give advance notice that they're going to enter this type of evidence. Rather, you're going to have to apply our third-party culprit standard.
So I would say two things to that. So one is that standard ought not to apply when the evidence is in a proper form that's appropriate for the jury. And to the extent that any cases have said that, I would suggest that the court ought to reconsider. That is, that connecting links, highly probative, shifting the sort of 403 analysis is not appropriate where you have otherwise competent evidence that someone else had a reason to commit the crime. That is appropriate when you're asking the judge to relax other rules of evidence, such as hearsay, Under those circumstances, it's appropriate to demand a greater showing of the defendant in order to introduce the evidence. But where the evidence is competent evidence, which is simply
Well, the Commonwealth versus Andre, for instance, relatively recent case dealing with ballistics from a 2006 case. Was there anything in that case where there were suggestions of diverting the jury's attention that suggested that a higher standard was applicable only in the context of hearsay, not within any exception?
To be frank, Justice Lowy, I can't answer that question specifically, but I'm happy to look into it and submit something if you would like. I guess what I would suggest is that to the extent that any cases have said that, perhaps the court ought to make clear that third-party culprit evidence, the rules for third-party culprit evidence should only require a heightened showing when you're asking something from the judge, essentially relaxation of other rules, but where we're simply offering competent evidence of what someone observed in a car, that rules of relevance are what guide us here, that it's relevant to the issue of motive. Either someone else had a motive or the Commonwealth stated motive is not what
So
ought to
are you
control.
arguing that that should come in even if there's no viable theory
I'm-
of it?
I'm-
I mean, even if the evidence wouldn't, as a whole, doesn't really support that theory, or you don't have the necessary predicates?
I'm sorry, can you
I
just
just don't
decipher if you
understand what exactly you want us to do with relevance and the evidentiary issue here.
I'm asking the court to apply and to hold the trial judge to a standard of relevance. The question simply is whether
As
the
opposed to what standard?
third-party culprit standard with a heightened showing required, connecting links and all of those things.
Right,
okay.
I think, so the connecting links line of cases goes to the admission of hearsay. That's what you talk about, the relaxation of the
Yes.
evidentiary rules. You're talking about the broader standard. There's two standards, two limitations to third-party culprit. There's a broad standard, then there's a standard for hearsay. And you think, obviously, that we should be only strict on the hearsay standard.
Well,
The connecting link.
it's reasonable to ask something more when you're asking a court to allow in hearsay, yes.
Right, but then with respect to relevance, how are the drugs relevant to the existence of a third-party culprit?
Well, I'm actually sort of not necessarily putting it in that box precisely, although I understand that that's what how it was framed below, and simply saying that it's and it was framed below in that way, but also there was a suggestion simply that it was relevant to the issue of motive,
Okay,
and that's
how are the drugs relevant to the issue of a third-party culprit?
so. In combination with other evidence that was introduced, it could have led to a third-party culprit argument, and here's how. So you have evidence of historical drug dealing that was introduced. That coupled with the evidence of active drug dealing on the night in question, coupled with the evidence of what transpired at the hospital where the victims and their associates indicated they knew who did it and indicated intent for revenge, coupled with the evidence that was introduced that Mr. Bookman remained at liberty and not under a threat or not under obvious retaliation for some 3 weeks after the event, could raise an inference that someone else did it. But the key piece to that was the evidence of active drug dealing on the night in question, and that's the piece that was excluded.
What was the evidence of active drug dealing on the night in question?
The possession of a quantity of drugs which could
Possession
give
of-
rise to an inference of an intent to
So
distribute.
it's the quantity plus the possession.
Quantity and in the packaging, in the way that it was packaged, could give rise to an inference. of
What
intent.
case says that if someone is a drug dealer, it means that there are other rivals that are gonna kill them, so you always get third-party culprit? What case says that?
There's no case that says that explicitly. I think in this
Case
case,
that actually says the opposite of that too, right?
so just the fact that someone sells drugs alone, of course, I'm not suggesting that alone would be admissible in every criminal case in which the victim has sold drugs.
There's this theory that Bookman was alive and well for 3 weeks or whatever, and nothing happened to him. Was this raised to the trial judge?
It was not presented in that way, no. That particular argument was not presented, no, I don't believe. Yeah. I mean, there was not, I think we all know what the record is as far as what Bookman's trial counsel argued, and wasn't, it didn't say a lot about it one way or the other. The co-defendant's attorney, was a little bit more thorough on this issue. But I think, we're on, 33E review here, so obviously it's not a situation where, obviously the standard of review matters, but it's not that all hope is lost if you find that it's not preserved, I guess I would
Are there
say.
any cases that say that if a defendant accused of a crime is not immediately arrested and they're around and there's no retaliation against them, there's got to be somebody else who did it?
No, of course, no. There are no cases that say that. No, definitely not. But I don't think there are very many cases where you have evidence that on the night of the murder, the victims in the presence of police officers say, we know who did it and let's go get him. And for whatever reason, it doesn't appear anything was done to stop them, which maybe is a different point. But it would suggest that they were looking for whoever did it and were intent on finding that person. I don't know how many times that situation has actually occurred. So no, I don't think there's any cases that say that gives rise to third-party culpa. But I'm suggesting that at all, or even that it's necessarily always admissible. But all of this put together is relevant evidence, I guess fundamentally is what I'm saying, that the trial court should have permitted. Should have permitted the evidence of the drugs on the night in question, which coupled with the other evidence that I mentioned, would have either suggested that someone else had a motive to commit the crime, or at the very least, rebutted the Commonwealth's theory that this was gang-related, or they didn't use the word gang, but related to rivalries between groups in the city of New Bedford. If there are no other questions, I can rest in my brief.
Thank you.
Thank you.
Attorney Lee.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. If I could start with the questions about Lewis Class and the murder that he was held on pending. So the Commonwealth filed a statement of facts to support its various motions in limine, and that statement of facts is in the defendant's record appendix. And at page 62 of the defendant's record appendix, it describes Lewis Class's charges, and it says Class was being held on a murder charge that involved the killing of a rival West End individual, Mateo Morales. This murder occurred approximately 8 months after the killing, and in retaliation for the murder of Aaron Gant. So that's obviously the Commonwealth's theory of it. I think part of the reason why trial counsel for Bookman, the defendant Bookman, that's attorney Jack Atwood, that he wasn't pressing anything about Lewis Class is because it doesn't help the theory at all. Class is from the West End, and the West End is where both defendants are from, Acevedo and Bookman.
It would have been consistent with the Commonwealth's theory.
I think you can draw that inference from the Commonwealth's proffer and the fact that attorney Atwood was not pressing to have the information about Lewis Class offered. So the jury heard nothing about Class. They didn't hear that he was charged with the marijuana in the car, the marijuana at his house after the car was searched, and that he was held on charges for killing Mateo Morales, because the Commonwealth's theory was that it was in retaliation for this murder of a person from the South End. So we have the June 2014 shooting of Bookman's girlfriend's house. Bookman goes to Florida, arms himself with something that can be inferred to be a revolver. He and his girlfriend return in the spring of 2015. In 2015, it's June 2015, that's when Acevedo, who's Bookman's cousin, gets shot in the leg. And then during that time period, Bookman and his girlfriend are seeing the people driving through her neighborhood, including the victim, Aaron Gant. Now, Acevedo was friends with Aaron Gant. He didn't like Watkins, he didn't like the other people involved with the South Side stuff. But he was friends with Aaron Gant, as was the person who obtained the car for Acevedo, Mason Soto. But Bookman didn't like Aaron Gant. He had a problem with him because Aaron Gant was one of the people who's driving through his girlfriend's neighborhood, staring them down, etc. And then Bookman's girlfriend's house gets shot up a second time in October 2015, and then Acevedo gets shot in the face in a drive-by shooting from behind, just like the previous shooting against him, only this time his jaw gets wired shut, his car is ruined, his girlfriend gets shot in the leg, Bookman's at the hospital, worried, pacing, and I think the jury could infer that's where the plan began, that's when deliberate premeditation begins. But they don't have to go there because you also have the renting of the car a week before, and then you have the connections between Bookman and Acevedo all day long, which starts around lunchtime, then the two calls from Acevedo to Bookman at 5 o'clock, they're together at Chuck's Liquors, they're together at Silva's Liquors, and then the car, which has some distinctive parts about it. It's a white Ford Fusion with the sunroof and the black rims. The surveillance security video throughout the city captures images consistent with that car driving down right into the South Side where the enemies of Bookman and Acevedo live, right onto Pleasant Street, which is where Class and Watkins, the driver, live. They circle through the neighborhood, come up behind Watkins' maroon SUV Mercedes, and then, of course, you have the 6 shots fired into the back of the car, which the jury could find deliberate premeditation, definitely intent to kill, from shooting into a car filled with 4 people. And so we believe Bookman, the Commonwealth's theory is Bookman's the shooter because there's gunshot residue on the passenger side near the A pillar in reach of the passenger seat. Bookman was the passenger back at Silva's 16 minutes before. He's the one who previously had a gun. The gun was a revolver that was inferably a revolver. His girlfriend who saw it was not by any means an expert in firearms, but her description is consistent with that. There's no casings at the scene, so that would be consistent with a revolver. That's why the judge let in that evidence of a prior gun and not the other evidence of Acevedo and Bookman having guns otherwise. And so, so that is what supports the 33E. So I'll go to then the first issue, which is the exclusion of evidence. The Commonwealth's position is that this evidence, that this should only be reviewed for a substantial likelihood of a miscarriage of justice. These claims were waived. Trial counsel is very experienced. Attorney Jack Atwood has been an attorney for long before I have been an attorney, well practiced in murder cases. And the judge in this case is also very experienced, Trial Judge Dupuis. And so I would suggest that the Commonwealth brought motions in limine. Counsel were specifically asked as to third-party culprit. Attorney Atwood said, I can't imagine. And the other attorney said, I don't intend on offering it. And that was allowed by agreement. That is a waived claim.
But we have at least the Commonwealth's motion to introduce drug dealing in drugs. Then we have an argument against that, at least by co-counsel. And then Atwood says, I think the jury ought to hear it.
That's on the drugs.
On the drugs.
Yes.
So I know he says I'm not offering third-party culprit, as does the other lawyer, but he does argue the jury ought to hear about the drug dealing.
Right. So that's why in my brief I offer the court both alternatives for how to find it. My position is should be substantial likelihood of a miscarriage of justice because the jury should probably hear it. I don't see much of a connection without any objection or motion. I suggest doesn't preserve it. I would also note that the judge allowed that motion without prejudice. She said they could raise it later if they could connect it up. And so it shows she knows the correct standard of the law, and she's just holding them to the right standard, that they have to make a proffer that shows how the drugs are connected. They didn't do that, even after the Commonwealth offered the evidence that 2 of the 4 people in the car were convicted drug dealers. Now, that was offered in Acevedo's jail tapes in his conversation with Michael Conrad. Michael Conrad did testify, and he was questioned about it a little bit. The statements of Acevedo could not be used against Bookman. There's an instruction on that. But Attorney Atwood for defendant Bookman never asked to have, I want to use that. I want to use it as third-party culprit. And certainly the fact that there's 2 drug dealers in the car better lends itself to the fact that there's 1.02 ounce of marijuana and just over 10 grams of suspected heroin in the victim's possession.
But nonetheless, we're dealing with third-party culprit evidence, which we've referred to as of constitutional dimension because it goes to the defendant's right to present a defense. And therefore, despite you may have taken a look at Commonwealth versus Rosa and Andre and the cases that have the heightened scrutiny requirement of relevance separate from hearsay. Not the substantial connecting links issue, but the substantial probative value and divert attention. But despite that, I recognize that it's not preserved. And when we're dealing with substantial likelihood under Silva Santiago, don't we sort of have to impose on that also that third-party culprit evidence is of constitutional dimension for the defendant?
You definitely have to look at, under plenary review, you have to look at the whole record and all the case law. We don't have a motion for new trial claiming ineffective assistance. This was not the theory that was argued. So preserved or not preserved, the defendants didn't make the proffer. They just said the drugs are there, and that's not a sufficient proffer under Andrade. It's not sufficient to just say someone's a drug dealer and therefore there must be somebody out to kill him. You have to connect it up, and that's all the judge was asking them to do. And they couldn't do it even after the Commonwealth had offered evidence that 2 of the people in the car were drug dealers. They didn't renew it. They could have. This was without prejudice, shows on the docket. And I think in terms of Bookman, it wasn't consistent with Attorney Atwood's strategy of the case. And under Tevlin, we look at the defense strategy at trial. What Attorney Atwood argued is, he wasn't arguing Bowden. He was saying, this was a fantastic police investigation. Look at this mountain of evidence. Look at all these security videos. And what have you got against my guy? No DNA, no fingerprints. You can't even see if there's somebody in the car when they're in South End of the city. You can't tell if it's Bookman. We can't even see if there's a passenger. And they got his sweatshirt, his black sweatshirt, like a week after the crime, no GSR on that. He's pointing out what a good, thorough investigation this was, but yet it's a circumstantial case. They got nothing. And I'm paraphrasing, but that's essentially the gist of his closing argument. So his theory of the case wasn't that there was some rival drug gang. It's that Bookman got out of the car. That was Bookman's statement to the police. He got out at Kempton Street. And the police can't show he was there. And that's Attorney Atwood's theory of the case. Not that some other drug gang was there. And under Andrade, it's not even enough to be present in the area. You have to actually show they're in it. And the video shows the white car circling onto Lewis Class's street, near Lewis Class's house, comes back around, follows the maroon SUV. The shooting's at 101 Pleasant Street. Junie J's Mercedes that has a projectile found in it that's consistent with the one found in the victim. That's at like 1:15, I think. And Lewis Class is at 1:12. And there's one car coming up behind it, and it's consistent with Acevedo's car. This isn't a good third-party culprit case. That's why both counsel ignored it. I'm happy to answer other questions on that. I would like to raise one issue that hasn't been briefed.
I guess I'd ask my same question again, rather than, and then move on, which is, putting aside your argument that this isn't how the case was tried and why there's no substantial likelihood, how does the fact that it's of constitutional dimension, the right to present third-party culprit, weave into the analysis?
Well, I think because it's waived in this case, it doesn't. And I don't mean to be glib about that. They can raise third-party culprit, but they have to do it. And they didn't. They said they weren't going to do it, and then they didn't.
So if I could just play back what I think you might be saying. If the judge at trial, it's offered and not admitted, then we're looking at that at more than an abuse of discretion, even in the context of third-party culprit. We're looking at it as something more.
Just the drugs themselves?
No, third-party culprit has this overlay
Right.
of constitutional dimension. And I think what you're saying is Okay, but it wasn't even offered at trial,
Right.
so
It was waived, and they had the opportunity to do it, and they had the opportunity to continue to do it throughout trial because it was without prejudice. The motion in limine was ruled on without prejudice. And so this just wasn't part of Attorney Atwood's theory of the case. This wasn't anything. He said, I can't imagine offering it. And that's not a constitutional error to have a manifestly reasonable strategy by competent counsel after proper rulings, using the proper law on the correct facts. That doesn't create a constitutional error just because the right to third-party culprit exists. I hope I've answered your question. So I'd like to address something that wasn't raised in the briefs, which is Commonwealth versus Guardado, which came out, I believe, April 13th. There's a conviction for unlawful possession of a firearm in this case. So that doesn't have any impact on the murder charge, but my brother has informed me that a 16L letter was filed on Friday, which, I'm sorry, I didn't check my email, so but I had seen that Guardado was coming up and looked into it within this case. And so unlike Guardado, this case was not raised in the briefs. Bruin came out last June, and so it could have been raised in the briefs like Guardado did. So I would suggest that it is not preserved. Although I'm fully aware that under Guardado, it's viewed under the clairvoyance exception to be preserved at trial, but this is different from Guardado because it wasn't raised in the briefs when it could have been. In addition, in this case, there was a police officer that testified that neither defendant was licensed to carry a firearm. That's at transcript 15, 2021. It's in a footnote in the facts of my case. I didn't realize Guardado was coming out when I wrote, otherwise I would have put it not in a footnote. That is corroborated by Bookman's statement to his girlfriend. She saw him at a cookout with the gun when he lifted up his shirt because it was hot out because they're in Florida. And she got upset about it, and he said it was his friend's gun and he got it for protection. And that's a transcript 12-123. And so that statement would indicate, like, if he's getting a friend's gun, that indicates that some corroboration for the police officer's statement that it was not objected to. I realize the police officer's statement is hearsay. It wasn't objected to on hearsay grounds. It was objected to regarding prior bad acts, and then the prosecutor said, I'll ask a leading question, and everybody's like, okay, fine. So unobjected to hearsay can be used as substantive evidence under Commonwealth versus Ashley, which is 427 Mass 620 at 627 to 628. And also more recently in this court's case in Capaya, 490 Mass 787 at 789 Note 1, which is 2022. But I have to acknowledge that the exact same incorrect instruction in Guardado exists in this case, namely that the Commonwealth didn't need to prove absence of a license, which would be error. And I would suggest that it's, one, the evidence was sufficient, so there's no need to do what was done in Guardado, which is to find that the evidence was insufficient and rule that there should be a verdict of not guilty. If anything, it should go back for a new trial just on the firearm charge.
I'm going to ask you about an inference that you just suggested, and help me understand why there is an inference from it. The fact that he says it's somebody else's gun, why do we draw an inference from that he doesn't have a license to carry?
Well, I mean, the transfer of guns is governed by, in most states, by regulations on how to sell and transfer guns. You can't just hand over a gun to somebody else. And so, and the inference is that that's the gun that was used in this case and was then brought up to Massachusetts. So I would suggest, I'm not suggesting by itself would be sufficient. I'm suggesting that it corroborates the officer's hearsay statement.
I'm just trying to understand how, and you're saying because...
Right, you just can't hand a gun to somebody else.
So because he didn't comply with that, you're saying there might be an inference that the gun's not licensed as well?
Yes.
Okay.
In addition to that, his girlfriend didn't want it in the house, and so he kept it out of her sight. She never saw it. They were back at the house, and she's like, I don't want it here. And he kept it out of her sight after that point as well. But that doesn't by itself, doesn't necessarily prove anything. Some people don't like having guns in their house. At any rate, I would point out that I would suggest it's not a substantial risk of a miscarriage of justice in this case, because after the close of the evidence, after the verdicts, the defendant pled guilty to a different firearm charge when he was arrested. He had a firearm with him, and that was excluded from evidence because it could not have been the firearm in this case, and then he pled guilty after the verdict, and so it suggests that shows that he did not have a license. and therefore that defense is really not a live issue at
How
trial.
does that get built into the case in chief, though? How do you chisel something after the trial and calibrate it when analyzing required finding?
I'm just saying it wasn't a live issue. It shows that it wasn't a live issue at the trial. But I understand that.
But we can't go there forward and then sort of catapult that evidence back into the...
I understand, and, I understand the position you're in, the position we're in, the law has changed in the middle of the road, and so now the instruction that was correct is now incorrect. And the prosecutor had to fight to get in the evidence that it was unlicensed in the first place, because the judge is like, you don't even have to prove that. And he's like, well, it's in the indictment, so I want to prove it. and then we get the instruction, which is now wrong. So I was suggesting that it wasn't a live issue because he doesn't have a license, so it wasn't hurtful to him at all, and that's why I think it goes to substantial risk. But of course, if this court disagrees with me, then I think the proper thing to do under the Guardado issue is to remand the unlawful possession of a firearm conviction for a new trial and on a proper instruction. But if this court disagrees with me, you obviously have the ruling in Guardado to govern that. I appreciate you hearing me out on an unbriefed issue, and I'd ask you to affirm the convictions in this case.